Whoever created it can control and regulate it. In 1974, government of Canada took Colgate Palmolive to court on an anti-combines case, and here's a quote from the judge in that case. If the Parliament of Canada or the legislature of a province can create it, it can control and regulate it. Well, who do you think created Canadian? The Parliament of Canada. So connecting back to the power of attorney thing, if you're claiming to be a Canadian or showing documents that says I'm a Canadian, then you're a Canadian, and the Parliament of Canada can control and regulate you because it controls and regulates Canadian because it created Canadian. Simple math, right? Something to ponder on. I'm back. How y'all doing? Previous video I talked about the power of attorney, revoking power of attorney, and I did say in there a few times to think it through. And the reason I said to think it through, or a reason, if you watched our videos here, one we talked about the attornment, and two we talked about two beings, same sounding name. So just have that awareness when you're doing the revoking of the power of attorney, because which one is doing the revoking? The real being or the fictional being? Two beings, same sounding name, right? I did say think it through. Just to be aware of these things, people. Part of your thinking, right? Yeah. So have that awareness in your thinking when you're doing what you're doing there, that which one's doing the revoking. Only one's going to be able to do it, right? Not the other. And a little update on the change of status website that was mentioned 2 or 3 videos before this one. That website is up and running and has been for a couple of weeks now. We're offering that information first, or access to that website first and foremost, to the people who do have a Reclaim Your Securities information package. They're receiving a particular link to join that. And once all of those people have received that opportunity and we've exhausted all of them, then will be a new video up here introducing the website to any newbies that haven't got a Reclaim Your Securities information package, anyone that's interested in getting involved, whatever, to sign up to that website. And I remind you, it's not my website. I'm not the IT guy. I'm not the administrator. Yeah, so that'll be made available at that time. So if you already have a Reclaim Your Securities information package, you will get a link to join it. If you haven't got it yet, you'll get it. Sit tight. And again, once everybody's received that, existing people, then we'll make it available to the via video here on YouTube to, let's call it the general public, to newbies. No disrespect. Yeah, that's all I came to say on this video. Just going to keep it short and sweet. Things are getting tight now and moving along really nice. A lot of people having a lot more successes, getting all kinds of feedback from people that have the Reclaim Your Securities package. Some of them are using it for Reclaim Your Securities purposes. Others are taking that knowledge and using it in their own way, which is wonderful. And those are the people, quite frankly, that are having the most success, those that are thinking for themselves and applying the knowledge and the information in their own way for their own situations. And everybody's situation is different, right? I think we'll all agree we all look different. I think that's enough said here for this video. Keep it short, sweet, on point. Love you. God bless. Light of God never fails. Keep smiling. Don't let the dark side get you. Shine the lights. Love you. I think I mentioned in that revoking the power of attorney video that we have a case here in Canada, XY versus HMQ. And that's where the Deputy Registrar General, the expert with respect to registering births, and she is or was the expert. She's retired now, but on the vital statistics and birth certificates. And she testified in that case, it's sworn testimony, where the birth certificate isn't. And again, this is unique for folks in at Canada because that's where the testimony exists. But point being is there's this case. It's a case of concealment of material facts. In other words, the Queen, although it's the Deputy Registrar General is doing the testifying. Remember, it's XY versus HMQ, Her Majesty the Queen. So although it's the testimony of the Deputy Registrar General, it's as if the Queen is speaking. So the Queen has the knowledge of what the birth certificate isn't, and the Queen did not make that information known to the rest of us. For example, in New Zealand, in the birth certificates in the bottom there in the fine print, there's a little blurbage there. It says, warning, this birth certificate is not evidence of the identity of the person presenting it. So that's disclosure. It's the only jurisdiction that I've seen that disclosure on the face of the birth certificate. In any case, for Canada here, there's no such disclosure, but the Queen, via this testimony, so we can verify that the Queen has the knowledge and the Queen didn't share that information. So that's what's considered a concealment of material facts. In other words, if you knew the birth certificate was not evidence of your identity, would you have presented it as evidence of your identity? And we're going to get into this in future video, but I'm going to leave it at that for you to think about. Give that some serious thought. Would you have presented the birth certificate as evidence of your identity if you knew it wasn't evidence of your identity? And if you knew it wasn't evidence of your identity and you didn't present it as evidence of your identity, what would your life look like right now? Keeping in mind that you need the birth certificate to interface out there in the public, but you don't have to use it as personal identification. So this falls under the rules of equity. Powerful stuff. Now, due to a lack of disclosure on the part of the Queen with respect to what the birth certificate isn't, that is grounds to void everything you've done with respect to presenting that birth certificate as if evidence of your identity. And let me qualify that here. They've changed it now, but it used to be on the application for a driver's license. And you had to use the birth certificate to apply for a driver's license. You had to provide the birth certificate. So the name that's on the form now is the name off of the birth certificate, right? That's the name that's the name that's recognized in law, period. And when you sign that form, where you put your signature, it says, I certify I am the individual named above. So you see, that's how you identify, that's how you use the birth, that's how it's evidence now that you use the birth certificate as evidence of your identity because you're by your signature. You certified I am the individual named above, and individual named above is like I say, the legal name off the birth certificate. Well, via this concealment of material facts situation, and I've done lots of studies on that. Quite frankly, we've had that case for a long time, but we were using it incorrectly. Wrong perspective. We're trying to take the Queen to court to file a criminal charge for the Queen concealing these material facts, and had the case laid out there and tried it in Newmarket Court. The Justice of the Peace refused to take it. Again in Coburg, a few days later, refused to take it. So that's when I realized, you know what, you're never going to beat the Queen in her own court system for violation of the law by the Queen. Not going to happen. So that's when I said, you know what, I'm not doing that ever again. And it wasn't until recently, quite frankly, that well, I was thinking about, here in Canada, Ontario, the Courts of Justice Act, Section 96 talks about the common law and equity. And whenever the two are, and that Superior Court of Justice here in Ontario has concurrent jurisdiction of common law and the rules of equity. And whenever the two are in conflict, the rules of equity shall prevail. And I know the history quite well on the common law versus equity thing. There was a time back in the past, long time ago, and there was no such thing as equity. This is how people were getting screwed out of the property because there's really no trust situation. They thought there was, but there wasn't. It didn't exist. Wasn't in the consciousness. Wasn't in the courts. Wasn't anywhere. Eventually, that's when he brought in equity to level the playing field to correct injustices, such as somebody giving their property to another individual to look after while he's gone to war. You know, the war times way back 300, 400, 500, 600 years ago, and coming back, and the guy wouldn't give him his property back, who actually owned it. And there's nothing they could do. In other words, the court said, well, he's the one in the house, it's his house. And so the guy who actually, gave his property for someone else to look after while his way got screwed out of his property. No recourse, there's no remedy. So that equity come in was created to rectify that, to the extent that whoever was looking after the property wasn't his property, he was supposed to be looking after it. Now he's claiming it as his own property. Equity says either you give the property back or you're going to jail. That's how it was. That's a very brief history on that. So then I took up the rules of equity. So okay, let's go to the Supreme Court of Canada and the judgment page, and I search rules of equity. That's rules of equity. That way it picks up the search phrase, the whole phrase for the search. And very revealing there. And so for example, I'll give you an idea here. I met with some people yesterday. We're going to get a bunch of people together here, hopefully in Ontario, maybe even further than that, to do this, but I won't get into all the specifics yet. But for example, you contract to purchase a car privately, whatever. And so now you've entered into the contract, you give the guy the money for the car and he gives you the car. You get home and you find out there's no motor in the car. Now this is paramount. You have to say this. If I had known there's no motor in the car, I would not have contracted to purchase the car. Bang. That nullifies the contract. You got to give the guy his car back, and he's got to give you your money back. There could be damages depending on the circumstances. I'm just keeping it real simple here. The point being is that had I known i.e. the birth certificate was not evidence of my identity. I would not have presented it as evidence of my identity. And when this happens, going back to the little car example there, it restores the party to their previous standing. Now think about that. Restores the parties to their previous standing. Now I'm talking about the birth certificate situation. When was it that you first presented it as evidence of your identity? Term and all that stuff comes into play, right? Submitted to the jurisdiction, the whole thing, the legal jurisdiction. Well, with this information here, you can, again, nullify all of that. It happened, but make it like it didn't happen. And all the parties are restored to their standing that they had before they did what they did, before they entered into these contracts, driver's license, social insurance, passport, whatever. Again, don't jump to conclusions here. People often do that. And it also brings in the concept of equitable estoppel. You see, the Queen knows this, but the Queen didn't tell us this. So at the end of the day, the Queen has no defense to this whole thing. So all of this stuff that you did with the birth certificate by presenting it as if evidence of your identity, all of that can be undone, nullified, right back to all of it. But we're doing it in a particular way. It's called a bait and switch. We talked about bait and switch on here. They bait and switched us. Well, we're going to use their own bait and switch against them. In a good way. It's not about fighting. It's not about retribution or revenge or anything like that whatsoever. It's just about getting back to your previous standing, man, woman, no longer, Canadian, fictional being, legal person, whatever. Quite frankly, what your name is doesn't really matter because the only name that they recognize in law is the legal name. And any name you give out of your mouth, if it sounds like the legal name, then chances are they're going to make the connection and say, well, that's, you're the person, the fictional being, whatever, or wearing the mask. So it's a very unique situation here, like I say, for folks at Canada, because we have this testimony in Canada here, although each province has its own Vital Statistics Act, they got what they call uniformity. So the words and the language may be different in the legislation, but the whole concept is exactly the same coast to coast. So it applies in Ontario, applies in British Columbia, blah, 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 blah. The birth certificate, like Judy Hartman told us in 2004, a birth certificate is not, it was never intended to be personal identification. It evolved. In other words, let's just say through our lack of disclosure by not having on the face of the birth certificate warning, this is not evidence of the identity of the person presenting it. We presented it unknowingly as evidence for identity. There could be some greed and selfishness in there that we implicate ourselves. I don't know, but point being is that now that you have the knowledge, and we can use that knowledge to undo all of that stuff. And there's no recourse on the part of the Queen. That's what the equitable estoppel is. Like if you want equity, you got to do equity, right? So exceedingly powerful stuff. Restores the parties to their previous standing. So again, back to the car example. The guy got a car without a motor, and he's out $5,000. The guy got that $5,000, doesn't have the car. So you give when you say I wouldn't have contracted to purchase the car had I known there's no motor in the car. Technically, a car's not a car without a motor, but that's neither here nor there. It didn't have a motor. And all you got to say is, I would not have contracted to purchase the car had I known there's no motor in the car. Bang, it's all nullified. And then, so you give the car back to the guy who's restoring him to his previous position. And you're being restored to your previous position. You got your $5,000 back. So it's like it happened, but it's like it didn't happen. Well, it's a little bit different than that with the birth certificate because first off, there was no exchange. There was no exchange of valuable consideration. Queen didn't give up anything, and neither did we when we entered this contract. So there's really nothing to give back. The only thing you get back is your standing previous to having presented that birth certificate as evidence of your identity. Going back to the very first time you did that for me, 1974. Yep, driver's license, social insurance were applied circa 1974. I don't remember. I'd have to look up my safe there where documents are, but it's all 1974, and the specific date doesn't matter. But so what I was previous to doing these things is what I get restored to our original standing. So I'd be outside of Canada then, right? I wouldn't be the fictional being. They wouldn't have jurisdiction. But like I say, we're doing it in a particular way. We're not voiding the contract completely. I can't say here in the public what we're doing on the perspective of that, but we're not voiding the contract completely. I'm taking myself out of it. But But I can't say any more on that here. So that's going to come, and we've already had a couple of discussions on this on our Zoom meetings during the Reclaiming of Securities, most recent, 2 recent Zoom meetings, in fact. Got in pretty good detail there, and it takes a little bit for it to sink into people. And the reason I'm kind of sharing this is I understand that the Reclaiming of Securities for a lot of people is very complicated, complex. We're not taught this stuff in school. Securities, what's that all about? People think, you buy stocks and bonds, blah, blah, blah. But here, what I'm talking about here is, and like I said, I had a meeting yesterday with a bunch of people, and the lights came on for them pretty much immediately. All you got to do is understand basic contract. And when you contract for something, you're expecting to receive what you contracted for, right? And so is the other party. But at any time, if there's a concealment of material facts, and if you do go to the Supreme Court website, their judgments page, that's where you can find all the decisions, and type in search rules of equity. If you don't do that, it's going to give you, you're going to get, the word equity of and rules individually. You want to search that phrase. There's a multitude of examples there. What happens when one party has knowledge and doesn't disclose that knowledge, pertinent knowledge, to the other party? It's called concealment of material facts and is grounds to undo whatever was done. And as I say, it could also lead into damages. I'm not saying we're going for damages, but it could go that route. But the main point is that the parties are restored to their original position before they did this, before you used the birth certificate as evidence of your identity, before you presented it as evidence of your identity. It takes you back to that moment in time before that happened. Love you. God bless. I should add here, too, that the particular testimony of the Deputy Registrar General in XY versus HMQ, you won't find that on the internet. You'll find a decision, but the decision is irrelevant. This is to do with the gender identity case in 2010. And the reason for XY is to conceal the identity of the individual that's going through this gender identity thing. Okay, so the decision is completely irrelevant. It's the testimony of the Deputy Registrar General that is critical here, and that can only be obtained via Freedom of Information request. And even then, it's tricky because there was a publication ban on that to protect the identity of the applicant in that case. But we were able to convince the people at Freedom of Information that the testimony of Deputy Registrar General was not disclosing the identity of that individual, so they agreed to provide the documentation. It's about 205 pages in total. Excellent read. People that got a Reclaiming Securities package received that XY versus HMQ case. They have that, the testimony aspect of it. I just wanted to throw that out there so don't waste your time trying to find it on the internet, and you don't waste your time looking at the decision in that case. The decision is irrelevant. Love you.